Koller, when you're ready, you may proceed.
Thank you, Your Honor. May it please the court, Ms. Kamienski, Jacob Koller from Simmons, Prine, Moyer, Bergman, and in this case I represent the petitioner Kent Langholz. This appeal does not involve a material dispute as to the facts. And in fact, the district court's fact finding was both comprehensive and well articulated. This case is about a parent, Kent Langholz, determined to protect his teenage girls, and in particular his oldest daughter, KML, from a softball coach and instructor, Mr. Brumbaugh, who in this capacity became a close family friend of the Langholzes.
Can I ask you to back up? I recognize that the actual injunction itself is not before us, or the injunction, the other side hasn't appealed the injunction. But what is the legal basis on which you got the injunction? I mean, what statute or what did Mr. Langholz, Mr. Brumbaugh violate, or what tort did he commit that you pled?
Your Honor, the statutory authority or the authority under Iowa law is through Division 15 of the Rules of Court and through case law on the standard as typical with any injunction of irreparable harm.
Right, but you still need some legal cause of action. What was your legal cause of action?
The legal cause of action, again, Your Honor, is in Division 15 of the rules. I think it's supported. There is case law as it relates to a permanent injunction, and it goes back to the standard of irreparable harm. I don't know that I can answer it any more specifically than that. In his capacity as a close family friend of the Langholzes, over the course of a year in 2012 and 2013, there were various inappropriate interactions with the oldest child. Those communications involved repeated requests from Mr. Brumbaugh to the child to delete communications, included various inappropriate interactions with the child on intimate subjects, conspiracies to conceal information, manipulation to prevent disclosure, and so on. At best, Kent and the child counselor believes that this was a precursor to what could have and would have been an inappropriate physical relationship, and at worst, Kent and the child's counselor believes that that physical relationship had already occurred. Either way, from any objective standpoint, the merits of the injunction itself, which prevent communication between Mr. Brumbaugh and Kent's children, are clear. Notwithstanding, Kent filed this appeal for two reasons. The first being that Kent challenges the district court's decision to seal the court file and to prohibit dissemination of the permanent injunctive ruling in any manner. And secondly, Kent asserts the scope of the injunction is too narrow, as it allows Mr. Brumbaugh to be present in the children's home when they are with their mother, which under
I know one of the actions that I think was the final action by the district court in this case was to go ahead and have the clerk issue a writ of injunction, which then prohibits all the details that were contained within a fairly lengthy ruling by her. Isn't that an adequate remedy to satisfy you and to satisfy everyone involved in this matter?
We don't think that's an adequate remedy, Your Honor, for a variety of reasons. One, although it sets forth, maybe from a law enforcement perspective, or really from an enforcement perspective, not necessarily law enforcement, what the prohibition is, what the limitations or the restrictions might be. What it doesn't provide is context for those restrictions.
Well, is everybody entitled to know what the context is?
I don't think everybody is entitled to know what the context is, but if you look at it from a public interest perspective, if the goal here is not only to protect these two children, but to potentially protect other children who might be in a similar circumstance, I think it's only fair that there not be a complete prohibition on the ability to disseminate that information. If you look at the district court's findings as to credibility, Count Langholz was deemed to be very credible. Mr. Brumbaugh and the children's mother were not. And so what is left when you just have basically the conclusion without the context is an inability to provide something more than conjecture and speculation.
Why does the world need to know the context? I mean, he didn't bring this action to protect every kid in the world. He brought this action to protect his child. And doesn't the bare writ protect his child? I mean, you got an argument it's not broad enough, but let's say it was broad enough to your satisfaction. Doesn't the bare writ protect your child?
The bare writ is adequate from an enforcement perspective to the extent that a violation occurs.
Well, how doesn't it protect your child? Maybe that's what the question I should ask.
Well, I mean, we're talking about a potential hypothetical, but Mr. Langholz, for example, is unable to protect other children, and in this case, other softball players, other potential students.
But that wasn't his cause of
instructor.
action. His cause of action was to protect his child, not everybody in the world.
Well, but I think part of the reason for the Iowa Open Records Act, for example, is transparency in court records, in court orders.
We also have confidential provisions in our code and in our EDMS rules that most of the information contained in that injunction probably would have to be redacted. So, I mean, where does it, what good does it do to publicize that this guy may be a no good guy?
Well, I don't think the goal and the intent here is to publicize, Your Honor. I think the goal and intent here is to follow what I think is the statutory structure that's been enacted in this state that provides that court records are public records. And in that same act lists 67 different exceptions to the general rule. And there are other statutory mechanisms.
There's information that's redacted from court orders all the time. I'm getting ready to teach an antitrust seminar next week, and over the lunch hour I was looking at the injunction issued in the FTC's action against Staples and Office Depot, and there in the official order there's all sorts of information redacted that I have no access to. But at the end, kind of similar to here, what the actual operative provisions of the injunction are out there so everybody can review them. What's wrong with that? Why isn't that enough?
Well, we wouldn't have any problem, Your Honor, with redacting personally identifiable information, and I think that is what Chapter 16, I think Rule of Procedure 1.422, other statutory provisions allow. This isn't an argument that you can't take some measure to protect particularly the identity of minor children. The goal here is not for Kent to relieve himself of his own desire to protect his children and information related to his children and also information related to his family. But to me, it's a big jump to go from whether or not certain aspects of this order should be redacted versus completely sealing the file from any access and from any subsequent dissemination.
Was the hearing on the injunction held in open court?
It was held in open court. I only paused there, Your Honor, because I don't know that we had
Maybe like today,
determination.
nobody was there, but we're being live streamed, I guess. What will your client do with if we reverse the order that sealed the rest of the injunction? What are his plans?
Well, I think his plans are to balance a fundamental interest that he has in maintaining the privacy of the nature of these concerns, which isn't to publicize, which isn't to distribute and to disseminate at will. I think it's, number one, a principal matter in terms of the court overstepping its authority to limit transparency and to prohibit dissemination.
Well, is
But,
the
but
real
two, I
re-
do think there's a valid interest.
Well, is the
and you-
remedy here then to remand it to the court so you both can hash it through the district court about what should or should not be redacted, or what is fairly subject to one of the exceptions that it can be sealed? I mean, it's kind of hard for us sitting here to try to make a determination. I think we can make a kind of an overall determination that the district court either did or didn't have the authority to seal the whole file and all the judgments and records and decrees, which is the issue that you're bringing up to us. But as far as the actual remedy, I'm not sure that, do you think we're able to tell you what the remedy is?
I think I would answer that in two parts, Your Honor. One, I think if it were remanded to the district court, there are already rules that provide for redacting personal information. I think the parties in this case have done an exceptional job of adhering to those rules by using initials as it relates to a child, and by not personally identifying people that otherwise should have their information kept confidential. I'd like to think that counsel and the court could do that based on existing laws. I think the issue before this court is the question as to whether or not a district court can, notwithstanding Chapter 22, the Iowa Open Records Act, notwithstanding the 67 noted exceptions that don't apply to this case, notwithstanding the other chapters and sections in Iowa law that provide for confidentiality, can the district court, for whatever legitimate reason, and I don't argue for a second that the court didn't have legitimate and genuine concerns as it relates to the privacy of this minor child, but given the legislature has comprehensively addressed this circumstance, the real question before this court is whether or not it has, as it cited, inherent authority to seal the file and to limit dissemination. That's where the petitioner in this case argues that it did not and that it overstepped its authority.
I mean, the concern, one concern might be that even though the child is identified only by initials, because the plaintiff's name is there and the defendant's name is there, it would be possible to figure out who this person is. And the district court might respectfully disagree with your client's view and might believe in good faith that it's in the best interests of this girl that that information in the findings not be available to the public. And isn't that within the court's authority? I mean, the court has authority to protect privacy of minors, it seems to me, as a general matter, right?
Well, I agree with your first statement in that every time I file a petition with the court and I use children's initials and I can see the names of the parties in the caption, I inherently question, how much protection does that actually provide? I think that's a fair consideration. It probably would be a better system to not go by initials and to go by some other less identifying measure, but that isn't the case here, and that isn't the case in terms of how that's been implemented to this point. As I already stated, I don't dispute for a second the district court's intentions here. It's a genuine concern. Mr. Langholz won't disagree that it's a legitimate concern, but that doesn't mean that the court has authority to do so. I think that a strong argument can be made that it's a slippery slope, that if the court can do it in this circumstance, and again, if it's not one of those 67 exceptions, if it's not part of Chapter 232 or Chapter 598 or Chapter 600.7, an argument can be made that what is the purpose of all of those other statutes?
We have case law that covers that. If somebody comes in and says, I need access to these confidential documents in this particular court file, and here's my need, then there is a process to do that. We've established case law on that. You know, and for example, in the situation where there's a tort suit against a manufacturer, and then somebody else has a claim against the same manufacturer, or potential claim wants access to the information, there's a procedure, right? And that procedure could potentially be available here, right?
Well, there isn't any sort of set procedure that's available here. I think it comes back to Chapter 22, the Iowa Open Records Act. I really do think that's the guiding post here, and that's not what the district court cited to. It's certainly not what the defendant cited to, but that's what we argue on appeal because we think that's where the analysis comes to. And there is a remedy or a mechanism in Chapter 22 for a party to request an injunction to prohibit dissemination, but that requires a hearing, that requires notice, that requires a petition and affidavit, and that requires court findings by the district court. None of that applied here. The only request to seal the file or to prohibit dissemination occurred after the ruling was entered.
Thank you, Mr. Koller.
Thank you.
Ms. Kamienski?
Thank you. May it please the court, Mr. Koller. I can't argue with the notion that there's no specific explicit statutory authority for the trial court judge to seal the file, but there's also no explicit statutory authority prohibiting it. The court was sitting in equity. Injunctions are an equitable remedy, and the judge was certainly within her authority to look at the interest of protecting the minor's information and things like that that are well established in Iowa law, and to incorporate those into her order. The appellant has argued that he would at times not be able to adequately enforce the writ of injunction if all of that information, if he were not allowed to share that information, and that's simply not true. As you mentioned, the writ of injunction exists. If we're, at a softball game or a school concert or something, all of these people have extensive child protection training, and they wouldn't need to know any more than, hey, there's an injunction, Brumbaugh can't be here. They don't need all of the lurid details of the allegations and some of the testimony in order to enforce this and protect the minor children. It's a well-established equitable principle, and I don't believe the judge was exceeding her authority or abusing her discretion in incorporating that in her order. I do believe that if this court decided that she were, the proper remedy would be to remand so we could go through the process of deciding which particular items to redact and things.
Now, you're anticipating then a proceeding under Chapter 22 mechanism that we just talked about under Chapter 22?
If you were to remand, yes. I believe that would be a proper procedure. Again, I'm not sure why Mr. Langholz would need to publicize the details of the order and the injunction in order to enforce it, other than he's looking to ostracize my client. And it's well established in Iowa law that punishment is not a proper role of an injunction. There were no criminal charges filed. There's no DHS finding. He talks about Chapter 22 and FOIA and things, but it's not a public interest. This was a private family relationship that did take a turn for the worse, but the child is now protected. There's no public interest at stake here that would justify publicizing all of this information.
Just so I'm clear, are you then relying solely or primarily on the inherent authority of the trial court to enter these kinds of orders? It kind of shifted during the course of the proceedings, of course, ending up as it did with the ruling in the second 1.904 motion. But is that what that's what your position is?
Correct. I believe it was within her inherent authority as a judge sitting in equity.
Is there any public interest in allowing greater publication of this in order to possibly identify whether there's anyone else in a relationship with your client that might take a turn for the worse?
I don't believe so, particularly given that my client has moved out of state subsequent to the proceedings.
What about the public policy argument in favor of transparency? And that includes, again, many of our court proceedings. Again, everything's in open court. It's meant to be an open court, except under those limited circumstances where we restrict access to the general public. But, you know, court proceedings generally are public. And so, as I think somebody started out earlier saying, there's nobody else here, but anybody else could be here. Just like they could have been in your trial over 2 days and heard all the lurid details themselves. What about that countervailing public policy argument?
That is a countervailing public policy, and I believe the judge, in entering the non-dissemination provisions, balanced those concerns and those issues. There's, you know, well-established case law and how that balancing is to take place. What harm is caused, what is the public interest, what harm would be caused to the parties. And I believe that she did that when she entered these particular provisions.
Should we defer to her finding that it was in the minor child's best interest to seal this?
I believe so, yes.
Is the case moot if he's moved out of state?
He does still have family in the area and may from time to time return for, you know, a week vacation in the summer and to see a softball tournament or something. So I don't believe it's moot, but it certainly does not need to be expanded or further restricted. I would yield to any other questions.
What bearing does the Osmondson case have? I mean, that was a case that dealt with jury lists and whether or not they were public record and so forth. It seems to suggest that the courts ought to be following Chapter 22. And although I don't know that there's any direct discussion, but the suggestion might be that you don't have inherent powers to seal records beyond express statutory authority.
I think when you're in the context of a jury trial, jury lists and things like that are inherently, they come from voter registrations and driver's licenses, other public records. That's a different situation than the personal details of a minor. They're all at least 18, we know.
Well, but you read the case and it seems like, I mean, it looks like just kind of a question of statutory interpretation under Chapter 22 and nothing else. Have I misread it? Which is possible, but I mean, you know, it talks about Chapter 22 and policy of openness and all this kind of stuff. And, it leaves me with the taste that Chapter 22 provides the roadmap here.
Again, it is possible that we're back to the balancing test. We have this statute that lays out that particular procedure, but also the court was sitting in equity. This is an equitable remedy. At what point do those two balance out, and does one get to trump the other?
But of course, I don't think we have any record of that here. You know, if we are looking at it through the lens of Chapter 22 and we have a mechanism set up so we can discuss those and argue what the countervailing policies are and do these things, we don't have any record of that here, do we?
No one has requested this information other than the petitioner, appellant, wanting to have the ability to provide that information.
But don't you generally follow the statute itself, which says we're going to have open records except for these 67 exceptions, but otherwise, you know, wouldn't you need to, I guess I'm just trying to think procedurally, wouldn't you need to say, we don't want this information disseminated? It should be a given that these are going to be open records unless somebody comes in and says, we don't want them open, or we don't have to provide them because it's subject to one of these exceptions.
And that may be the case, that if you were to remand, then we would have to go through that procedure and make the request again through that procedure rather than relying on the judge's order.
Thank you, Ms. Kamienski.
Thank you.
Rebuttal, Mr. Koller?
I appreciate the interest in the inquiry with regard to, well, why isn't this good for everyone if it's not accessible and if it can't be disseminated? What I can tell you is that there isn't any sort of untoward motivation to publicize. It's certainly not the word that I would use. The question is, again, authority to limit access and to prevent a party from disseminating an order, which I think really is a separate question from whether or not the court can limit public access to a file. Can the court go beyond that and prohibit a party, an individual, from disseminating that information as it may be necessary for good reasons, not bad reasons? And I do go back to the district court order, which provided this concern that the children's mother and Mr. Brumbaugh were aligned, that the mother has difficulty, given her bias for Mr. Brumbaugh, to protect these children from harm. And when all you have is a snippet of information, the injunctive relief paragraph, then in reality or in implementation or as a practical matter, then Kent is left to fend for himself and to defend for himself what he knows the district court order says, but in reality, there might be two other people providing or sharing an inconsistent message. And at the end of the day, that ruling means something. That ruling is important. That ruling might make a difference to the softball board, to the next family that uses him as an instructor, to the next team that he coaches. And when you take that in combination with Chapter 22, with the statutory provisions that do say when something is not accessible to the public, then to me that's an issue that this court can and should decide. And it doesn't require a remand to go through a process that nobody raised throughout the course of these proceedings until the appellate briefing, and mostly by Mr. Langholz, and the arguments here today.
You know, the parents disagree in some respects. Was there ever a or should there be a guardian ad litem appointed for the minor child if we remand it? Or if that didn't happen below, why not?
Well, in the 6th Judicial District, oftentimes an attorney would be appointed for a child, obviously a technical distinction between that and a guardian ad litem. We didn't ask for that to be appointed in this case, primarily out of concern that we didn't want to involve the children in this proceeding. Also a reason why Mr. Langholz didn't pursue a modification of the decree of dissolution of marriage. Really, the children were not witnesses in this case. They were not involved in the case to any extent, and we felt like there was some merit to keeping this between adults to the extent possible. I don't know that I specifically answered your question. Should, in the event of remand?
I'm just concerned, we have the trial judge who's has the front row seat to this dispute, made her own determination that it was in the best interest of the child to seal, and then we have parents disagreeing over that, and it might give me a little more comfort if there was a guardian ad litem looking out specifically for the child to advise the court.
Your Honor, I would hypothesize that a guardian ad litem would likely come to the same conclusion as the district court in terms of the utility of not having this information out in the public. I'm telling you that Kent Langholz would agree with that. But the question still comes back to, without regard to what the district court believes, without regard to what a guardian ad litem might suggest, does the court have the authority to limit access, to limit dissemination, and at the end of the day, to limit transparency. And again, I think that's the question that's before the court, and I think it comes back to Chapter 22 and the other statutory mechanisms. I will say, however, at the beginning of the case, the parties stipulated, consistent with Chapter 598, specifically 598.26, to sealing the court file similar to how you would do it in a dissolution of marriage case. But even in a dissolution of marriage case, you can seal the file, but you can't seal court orders, judgments, and decrees. We're still agreeable to that sort of mechanism. Is there authority for it? I think that's an arguable question, just like what's before you today. But I do think pursuant to Chapter 16, pursuant to the rules of civil procedure, an argument could be made that the entire file could be sealed with the exception of court orders, judgments, and decrees.
Thank you, Mr. Koller.
Thank you.
The case then is now submitted to the court, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.